Good afternoon, everyone. Thank you so much for being here. I would like to welcome you to our webinar on From Indecision to Resolution, Navigating Family Law and Child Protection Matters, which is hosted by METRAC, Action on Violence, with guest speaker, family law lawyer, and Deputy Judge of the Superior Court of Justice, Vanessa Richards Thompson. My name is Andrea Collins Fitzpatrick, and I'm the Legal Director with METRAC. Today, I would like to begin with a land acknowledgement. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only, and it is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. I would like to note also that we may be discussing some sensitive content, and this is a safe space, so please make sure to exercise self-care. This webinar will be recorded and reflects developments in the law before today, October 22nd, 2025. It will be posted on our website at onefamilylaw.ca along with the PowerPoint slides. We will have time for questions, and so please post your questions for Vanessa by using the Q&A function at the bottom of your screen. Before I move to our presenter today, I would like to tell you a bit about METRAC for some of you who may not be familiar with us. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLU, series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, that's onefamilylaw.ca, for more information on your family law matters. I'm very excited today to have Vanessa Richards Thompson to speak to us about From Indecision to Resolution, Navigating Family Law and Child Protection Matters, and thank you all for joining us today. Before I introduce our presenter, I'd like to thank our team, Fiza Malik, our project lawyer, and Macau, our coordinator, and our technician, Ferdinand Wilhelm. I would now like to introduce our presenter, Vanessa. Vanessa Richards Thompson was born in Jamaica, where she previously practiced law. After immigrating to Canada, she requalified here and was called to the Ontario Bar in 2009. Vanessa is a panel lawyer for the Office of the Children's Lawyer and passionately represents the most vulnerable members of the society, including visible minorities, victims of domestic violence, and at-risk children and youth. In 2021, Vanessa became the first ever Black president in the PE Law Association's then 75-year history and was returned as president for a second term ending in 2023. A very, very wonderful achievement. In addition to her work with the PE Law Association, Vanessa volunteers with several community organizations, including volunteering with children and youth, and currently works as a Sunday school superintendent. Vanessa has authored articles published in both the Jamaican and Canadian media and is a sought-after inspirational and motivational speaker and poet. In fact, her first book, Poetry Poised to Promote, was published in May 2024 and is available on Amazon and has been given a 5-star rating. As you can see, she's not only a fantastic lawyer. In 2024, Vanessa was shortlisted as one of the top 75 immigrants in Canada and is the recipient of several awards from both legal and community organizations. In February 2023, Vanessa was appointed a deputy judge of the Superior Court of Justice Central West Region. When not doing legal work, Vanessa is an avid walker. She enjoys traveling to historical places, reading, decorating, listening to gospel music, and spending time with her husband and her two miracle boys. Please enjoy the presentation this afternoon. I'll pass things on to Vanessa.
Thank you very much, Andrea. Thanks to MedTrack and the entire team for having me today. Thank you so much for that introduction. It is my pleasure to be here today and to share some information on an area of practice that means a lot to me, and certainly also to share information with those this information may assist most. So today the topics that we will cover are parenting arrangements, so that we get an idea of how to navigate from decision-making, responsibility, and parenting time. Then we'll talk about some parenting arrangements. We will try to navigate divorce, child support, spousal support, and property division issues. We'll talk about the most important and excellent way to tell your own story. And then, if time permits, we may put a little bit of meat on the bones in telling you how to put your child protection plan together. All right, so we will start with the overview. We'll start with generally what family law issues could come up in your proceedings if you have a matter. And if it's before the Ontario Court of Justice, which is a provincial court, we'll have areas which I call, and many family lawyers call the big five. You know, like you have the big five cats or the big five landmarks, we have the big five areas of family law. And these are decision making, which was formerly called custody, parenting time, which was formerly called access, health and medical decisions, education, and extracurricular activities, including faith. And a bonus related point is travel, passport, and document rights, which is all government issued documents. But the big five is where you would try to fit all the areas that would pertain to you and your family, especially your child, if you're seeking to make decision making for them and if you're planning some parenting time for them. So decision-making responsibility is generally those things that would affect your child's life and well-being significantly. So those would be things like the child's attendance at school, what religion you would want that child to be raised in or to be guided by, medical decisions. Those could be different depending on your faith-based. And then, of course, extracurricular activities, the significant ones which would guide them in the way that you would want them to go. Perhaps your child is sporting inclined or academically inclined. You would want the extracurricular activities to line up with those so that you have them involved in those activities that would promote the development in those interesting and important areas so that they would become more ingrained in those as the child grows. Decision making is not the same as parenting time. Usually one parent, who we call the primary caregiver, is the person who would make the decision making if that's what the parties have decided on or if that's what the court has decided on. It is different from parenting time, which was originally in the old legislative language called access. So the person who has decision making has the primary responsibility for the child and would be making the decision, and the person who has parenting time is the access or visiting parent. Decision making does not determine how much time each parent spends with the child and how much child support is paid. So what is decision making? A person with decision-making responsibility can let somebody else be responsible for the ordinary day-to-day decisions for the child, such as when and what the child is fed, what the child's activities on a daily basis would be, how the child would be looked after if there's an injury or a medical decision to be made. People like teachers, babysitters, and another parent can be responsible for some of those ordinary decisions on a daily basis. All right, so let's talk about the types of decision-making responsibility. And the type of decision-making responsibility will depend very much on your family situation. So there is sole decision-making, which means all of those major primary decisions are made by one parent. And depending on the circumstances, it would be mom or dad. Most often in the circumstances that come before us or in the court processes, traditionally it's been the mom, but in their cases where it could be the dad or other caregiver as decided by the family. Okay? Sole decision making is a situation where the court or the parties have decided that this one person is the main person for caregiving role for the child. Joint decision making is a little bit different. It is where two parties are making the decisions for the child jointly. And that is only possible in a situation where the parents have the ability to co-parent. They have the ability to make decisions together. Sometimes they have decided that this is the way that they are going to proceed because it's how they've already adjusted their lives during their family's life, and so that they have decided that they will continue in it even in a separated format, that they would make all those major decisions for the child together. Shared or divided decision-making responsibility is a little bit different. It can be the parents have said to them, to themselves and to the family unit that for this child, one parent would make some decisions for major medical and educational things or educational purposes. And then one parent may make all decisions related to religion and extracurriculars, or faith and extracurricular, for example. But they've decided to share or split or decide the decision making separately. Perhaps one parent is stronger in terms of communications and wants to be the one that has all those interactions with the healthcare provider or with the education providers, for the teachers, for the schools, for the school council and so on. Whereas another parent may be more comfortable making those decisions relating to extracurricular and sporting. Perhaps they were originally sporting inclined, or they're involved in the sports or in the arts, so they would make those decisions. And so the family has decided to share those responsibilities for the child. So again, it's tailor-made for your parenting, for your situation. It will determine what parenting decision-making responsibility is made for your family. You have to know which one is just right for you. So now talking about parenting time. In the old language, this was called access, but the legislative changes are made so that the language is softer and more inclusive and more congenial. So parenting time is that time that the parent spends with the non-custodial or non-decision-making parent. And so that time is a time that the child spends outside of the person standing in the major role of parent. So this is formally the access parent, and it's determined separately from decision-making responsibility. And it is up to the parties to decide what that parenting time will look like. If the parties can't decide it, then the matter, if it's brought to court, then the court will decide based on the circumstances available to the family what parenting time would look like. It may affect the amount of child supports that are payable because of how much time is spent with or away from that parent. A parent has the right to apply for parenting time with a child even if the parents are separated, or if they're never married, or they've never lived together, or they didn't even have an ongoing relationship. But the person seeking parenting time has a right to make that by virtue of being a parent. And it's not only that parent's right, it is also the right of the child to have parenting time with a non-custodial or non-decision making parent. Parenting time will again look different based on the circumstances of the family. So the most generous parenting arrangement is what is called reasonable parenting time. And that could be anywhere from several times a week to every weekend to every other weekend. It depends on what the family judges that it's most important to them or most feasible. It could be a fixed parenting time. It could be every Wednesday, Thursday, Friday on every other week. It could be weekends only, depending on the circumstances of the family. But it's generous and it's reasonable because that's what the parties have determined works best for them. If it's not reasonable or if it's not fixed, it could start out being supervised parenting time and then be graduated to something closer to a fixed parenting time or a reasonable time. Sometimes it has to be supervised originally because there were circumstances that required that supervision. But if the parenting time is going well and the interactions between the child and the parent is beneficial to both, then it may be moved up to reasonable or fixed parenting time. There are circumstances where the situation is such that there is no parenting time. But again, that will be based on the circumstances applicable in that case and to that family. It may have been an issue where there was violence so egregious and sometimes involving or against the child that the court and the parties have decided or determined that there has to be no parenting time. Okay, child support. Child support is a legal duty that requires parents to financially support the children that they brought into this world. This duty continues after divorce or separation. If the child lives with a parent for most of the time, the other parent must help the child with the cost of raising the child. And children's right to get financial support from their parents is an ongoing right, and it is applicable to both parents. Whereas it may be in varying degrees, both parents should be ensuring that the child is properly supported. The parent who pays child support is called the payor. The parent receiving child support for the child is the payee. Child support amounts are focused on the needs of the child and based on the income of the pair and not on the pair's needs or spending habits. It will always be based on the interests and the needs of the child. Child support will cover such things as food, clothing, housing, school costs, and then there's a special cost which is called extracurriculars or Section 7s, and those are additional if the child is involved in extracurricular activities or has extra needs such as childcare. So when determining child support or trying to determine child support, there are certain questions that have to be asked. One is child support payable? And if it's determined that it is, because there's one parent who is providing most of the caregiving and another parent who is potentially or possibly the one exercising parenting time but not physically caring for the child on a day-to-day basis, then it has to be determined how much child support is payable based on their income. Then, how will it be payable? Much depends again on the circumstances of the parties. It may be payable by e-transfer. It may be payable through the Family Responsibility Office. That will depend on what the parties determine is most feasible, most efficient, most applicable in their circumstances. Sometimes it starts out being payable through the Family Responsibility Office, and then the parties can determine at some point, oh, perhaps we can do this on our own. We no longer need FRO, and they could make their own arrangements and say, pay directly through e-transfer, pay directly by post-dated checks. Again, it will depend on the circumstances of the parties. Child support is ordinarily payable until the child reaches 18, or if they go on to post-secondary until they finish their first degree. All right. So if you are a person planning to take on family court proceedings, or you are in a circumstances where your family is such that you recognize that things are going in a certain direction and you need to take steps to commence a court application, the first thing you start doing is taking those preliminary procedural steps before court, which I would say are most important because you have to start creating that documentation for the court. So, my advice to clients who come before me is, if you're planning on starting court proceedings, if you're thinking that I need to make an application, document, document, document. Start writing down the things which you think will be important to the case that you're going to bring to the court. You're going to start writing down dates. You're going to start writing down details. You're going to start making the case for why the child should be more with you, or why this parenting arrangement is the best. You are going to have to start being proactive in putting your plan together to make your application as sound as possible. Remember, if the situation arises where you suddenly have to be removed from your home, or the other party is suddenly removed from the home, it is not the time to be starting your documentation. You have to commence the documentation before, so that you can be ready for whatever proceedings will come next. And I usually say to my potential clients, don't wait until you're served with an application. Start thinking, if an application needs to be made, let me start the application so I'm not responding to something. You may not be able to remember everything when the situation starts actively going forward. So you start documenting beforehand. For example, documenting may mean taking pictures of bank statements or copies of passports. If you see that there is a scenario where the other party is trying to always be holding on to the passports or the health card or other government issued documents such as a birth certificate, then you start doing the things such as documenting those, whether digitally or in paper format, so that you will have those documents that you will need to proceed to court as needed. All right. If you are preparing your application, you have to do a plan for your child or children. So in your application, you are going to highlight, focus on those plans and goals that you have for your child or your children, and include all those social, educational, religious, or faith-based needs that they have or will have. If the child is too young to be making specific decisions, then whatever your plans or anticipated plans were for them, either when you were planning for this child or when you are a family unit, start putting those into your document so that the court knows what the anticipated plans are for those, or for those children, and include those persons, family members. Sometimes it's a relative, but sometimes it can be a community member who will help to make those plans viable. Perhaps you work 8 to 4 or 9 to 5, but a part of your plan will be the caregiver, the babysitter, the person who picks up the child from school. Maybe there's another parent who usually does the ride sharing with you. Those are persons who you would put as part of your plans, because they will make your plan more viable, and the court needs to know about those persons so that there are no gaps or loopholes in your plan. When putting your plan together, you will need to do a financial statement. Again, the financial statement is important because the court needs to know that this child will be provided for. So in your financial statements, you're going to write down all those financial pieces that show that you have the ability to care for the child, your notices of assessment, your income tax return, put those into the plan. Put what you spend on formula or diapers. Put what you spend on those extracurriculars in which your child is involved at school. Put if you have to pay for their cadets or their scouts or their hockey or any other important thing, so that when you are requesting child support, it's a realistic amount of child support and the court knows why it is realistic. Or if the other party ordinarily pays for the extracurriculars, you are going to put in your child support, in your financial statement, that you cover this cost, but the other party has ordinarily covered the other costs, and why they should continue to do that. Make sure to be honest in your financial statement, because it becomes a sworn document and the court will have regard to what was put in there, and the other party can test your credibility or question your credibility if there's any information in there that is not exactly lining up with the facts. So it's important to be honest so that you can later be relying on that evidence. If your matter is before the Superior Court of Justice, which is the upper court, that court deals with issues relating to divorce, again, child support because it affects children, but it also involves spousal support and property division. And this is for a family where perhaps there was a family home, a matrimonial home. Okay? This application before this court will ask you to show how that property was acquired and how this property should potentially be divided. But a special consideration for all families that come to the Superior Court, it is important to note that child support will always, always trump spousal support. That means if you are making a claim for spousal support because you've been married for 10, 15, 20 years and you are looked at the guidelines and you're entitled to support, but the child is also entitled to support. If there is not enough money available from the payor or the spousal support or child support payer, child support will always take precedent over spousal support. So the court may ask you to take a look at whether or not you will forego spousal support, whether or not spousal support will be for a lesser period of time, whether or not spousal support will be in a lesser amount, because child support will always take precedent, because child support is a right of the child and it's both parents' duty to protect and provide for that child. So if you're going to the family court, the Superior Court, start by doing your research. Look at what your case is going to be about. If you're going to focus on getting your spousal support for your child or children, or look on whether or not you'll be looking for property division so that you can potentially more properly support the children. In either case, find a lawyer that represents you, your values, and your interest. I always say to my family law clients who come before me, you are interviewing a lawyer as much as they're interviewing you. The lawyer is interviewing you to see the foundational pieces of your case, but you are interviewing the lawyer as well to see if it's a good fit, if they are hearing you, if they are speaking to you in a way that represents who you are. Persons have come to me and they say, I want a lawyer who is a shark. Well, first of all, I think they're watching too much American TV, but also I want to let them know, okay, what does shark mean to you? Because shark may not be the way I practice. I practice in a more conciliatory manner. I'm looking more in terms of ensuring that your rights are protected, not so much in terms of the vigorous, loud representation that you may be looking for. Perhaps my way of practice is not in line with the way they want to have their case put forward. my way of practicing is picking up the phone and calling the other lawyer and say, what can we resolve? What can we settle on before we go to court? Make sure that that lawyer sees you, hears you, and is putting forward what is important to you. Then ask the lawyers the questions about the process, about the timelines, about interactions with the other party. Some potential clients are thinking that it could be a quick thing, and we go to court this month and we're done next month. That is not practical in today's family law courts, where the courts are overrun and backlogged. So it is important to ask the lawyer, how long will this take? How much time do I have to put in? If you're funding the family law proceedings on your own, you need to know how much it's going to cost you, and to make those kind of arrangements to ensure that the lawyer continues to be paid. If you are on a legal aid certificate, or if you're legal aided, you need to know if legal aid is going to fund it all the way from start to finish, or if legal aid is going to say, I have to put a lien on your house, or you have to go on a payment arrangement with us. These are questions that you have to ask to make sure that you know what is important for advancing your case. Okay. Telling your story. I cannot emphasize enough how important it is for you to be the one that's telling your story. So whenever parties come to me and they want to start a family court proceedings, I always give them the blank forms and I say, you start writing it, writing the case as you see it. Tell your story in the blank forms, because you know it better than anybody else, because it's been your lived experience. But then I also make my clients understand, when you give it to me, I am going to tweak it. I'm going to massage it. I'm going to put it in legal language. I'm going to take out something that it may seem very important to you, but I think the court will see it as inflammatory. I have to edit it. Sometimes parties want to tell the story about all the terrible things that the spouse did. And so this is why they should get the divorce. And yes, they should absolutely get the divorce, but Canada is now a no-fault jurisdiction. So the court doesn't really care about how many times he or she was unfaithful. What they want to be focused on is if the marriage is broken down irretrievably or irrevocably. And so there is no going back. And that 1 year has passed since the parties are separated, so they have the legal right to apply for a divorce. So sometimes that's difficult for parties to hear, but it's important for me to say, to share with them, to let them know that this is not going to be our focus, and for these reasons. And this is more importantly said this way, and for these reasons, because I don't want to prepare an application that is full of all kinds of information which I know the judge is going to ignore, because the judge is looking for things such as, has the 1 year passed, so that the divorce application is important? What are the arrangements for the child? What are the plans for parenting time? Those are the things that the judge is going to be looking for. In your application, when you're telling your story, talk about the difficulties. If there has been domestic violence or intimate partner violence, it's important for the court to know that, because that will inform what is important for the child and for the family, for the client going forward. If there has been intimate partner violence, then the court needs to know that, yes, perhaps this should be a supervised parenting time arrangement, so that the father or the mother can't just turn up to the former home, knock on the door, and be expecting that the child has to be exchanged here, because there may be child criminal charges outstanding or pending or not yet resolved. There may be a no contact order. There may be, even if none of those things are no criminal court proceedings, there may be that inherent fear of that partner who was violent to the person who is bringing the application. Sometimes violence is not physical, but violence is mental. Violence is financial or emotional. It's important for those difficulties to be put in the application so the judge, the court understands the background pieces that will affect interactions with not just the other parent, but with the child. Refer to the present situation and the remedy that you're seeking from the court. Sometimes I am duty counsel at the court several times a month in child protection and family court. And I'm often surprised how many times people do their applications and they've thrown everything in the application and they fail to ask for what they want from the court. And it's often heartbreaking for me because you can't get what you haven't asked for. So sometimes people get so focused on, oh, this happened and this happened and this happened, and they forget to say, because this happened, I need these things in place. I need to ensure that child support goes through FRO because we tried an arrangement before where he was supposed to pay on the 15th or where she was supposed to pay on the 1st and they didn't. So we've tried that. So you want to tell the court not just what the current situation is, but the remedy that you're seeking from the court. All right. Whenever we are encouraging our clients to prepare their application, their court proceedings, I always say the easiest way to do it is the age-old way that we did in elementary school. We ask those who, what, when, where, and why questions. Because otherwise you'll get boggled down in the weeds and you're not able to train your thoughts, especially again because it's a lived experience and it's a lot. So you may want to put everything on the paper, but you only have limited space and the documents have only limited page lines. So you want to just focus in on who. Well, it's if it's mom or dad, you're the child's parent. What? You're seeking sole or joint decision making and these terms of parenting time. And this is why. When do you want it to start? And when have you been doing this for? So if you've always, since separation, had only every other weekend and it's working well, then you tell the court, well, when we separated, we started doing this and it's working. Or you could say, when we separated, we started with once or twice a week, but the child is getting older and the child wants to see the other parent more, so we're going to start by improving gradually. Or you may say, the child is still breastfeeding or nursing, or the child is in daycare, or the child is still too very anxious around that other parent because of what happened. So this is how it should look. Where often includes a lot more input than parties realize. I always say with your where, start with where you live and spread out from there. For example, if you live in Brampton and you live near to a Tim Hortons or a McDonald's or a strip mall where you and the child or you and the other parent always went, that could be a potentially good place for exchange time, for parenting time, a pick up and a drop off spot. If you live in Toronto and you're ordinarily near a mall, or if you're near a soccer field where the child always plays, it gives you the opportunity to be creative so that even though the family is separated or the family circumstances have changed, you keep as much regularity and stability as you possibly can for the sake of your child and for making things easier for pickup, for drop-offs, for exchanges. Why? Why is important? Because you're going to focus in on this is in the best interest of my child because Because when you are doing your application, and it sounds harsh when I say to parties, and it's not meant disrespectfully, but it's not just about you. It's about you and whoever you're providing care for. So that little person whose best interest everybody has to focus on. So the why of it is always important. Why do you think this is in the child's best interest? It may be because a child was exposed to intimate partner violence or was a victim of violence themselves. So that is why you would ask for supervised access. You may say, I need to ask for supervised access and or exchange at a police station because I am fearful and the child is fearful. These reasons will generally be a bit different for each family, but there will always be common themes that run through, and then those that are unique to each family situation. Child protection proceedings are a different creature. And if you're dealing with a child protection proceeding, you're either responding to one because it's been commenced by usually responding to one because it's been commenced by a Children's Aid Society. So first of all, the most important thing is know what you're responding to. And it sounds trite, but I often have clients who they come to see us and they haven't looked at the application. They haven't seen what the society is asking for and why. Often it's a coping mechanism um, because they don't want to see what's in there. So they come and they drop it before the lawyer and they said, the society took my child away and this is what they served me, but they haven't read it. It's important to read it, even though it's difficult, because you need to know what is the ask and what needs to be resolved. So focus on the issue. The issue is, for example, the society is saying, we took your child away because there were concerns because the child wasn't attending school regularly. And the right to education is a fundamental right, and you're denying the child of that right. So we took your child because you haven't been sending the child to school. So put your plan together. Your plan is to respond to that concern raised by the society and suggest how it can be addressed. So you may suggest, okay, I was not sending my child to school because I was dealing with all these other issues because my family life was falling apart because of intimate partner violence, or because I just came to Canada. I'm a new immigrant and my focus was just on a roof over our heads and food on our table. We just didn't get around to the attending at school right now. And then start putting the meat on the bones in terms of, well, now that you've raised it and I see how important it is, I'm going to start by doing these things. Perhaps you're saying, okay, I don't understand or appreciate the differences in the Canadian educational system. I want to educate my child at home. Put a plan together as to how you can do that. What curriculum are you going to use? What will your plan look like? Because you need to address those concerns raised by the society in a way which makes them feel like, okay, the child is safe with you, these concerns are addressed, and we can make different decisions. I often say to families, when you are putting your plan together, find those culturally appropriate or culturally sensitive resources and connections that help make your plan work. For example, if a family is potentially responding to a case by the society, by the CAS, because of mental health and addictions concerns, you're gonna partner or tell the society that you're partnering with those community organizations that you can relate to, that you understand, that will understand you. For example, it may be, if it's a South Asian family, it may be Indus Community Services. If it's an African family, it may be a Coma or Roots Community Services. if it's a Caucasian family, but they identify as Catholic, they may want to go to Catholic family services of Peel or Toronto. They want to they want to connect with those services that they identify with, and that will help them most. Make sure that whoever you or your family are reaching out to for support, they get you, they hear you, they understand you, because that would mean that they can serve you better. So culturally appropriate services and resources are extremely important. Overall, whether it's a family court proceeding or it's a child protection proceeding, you have to focus on certain steps to ensure that you get the results that you want when you go to court. Because court in and of itself is stressful, it's onerous, it's not designed for empathy and understanding at its core. It's an adversarial system. So if you want to get the results that you need for your family, there are certain things you have to do. Again, as I mentioned before, be proactive before the action starts. If it's a family case and you start seeing the signs, or you're realizing that your family, your relationship is heading in a different direction, there are problems and they're becoming more evident, they're becoming more prevalent, start writing things down. Start putting your plan together. Start thinking about what actions do I need to take to help my family. Then be vigilant. Same thing I was saying about asking for help, connecting with those services. Whether it's the application you're commencing or the answer that you're preparing because the other party has served you, ask for assistance. Get a lawyer, talk to a lawyer. Sometimes it's getting a counselor because you may have endured a lot and bottled up a lot and dealt with a lot. So you need to make sure you're in the right place before you can start preparing for court. And because that in and of itself is a traumatic and stressful process. Start getting those answers. Start getting that wellness, that self-care that you need. And some of these resources, many of these resources, community-based ones, are free, but you have to start looking for them. You have to start connecting with them. Have a conversation with a shelter near you. Find out if Legal Aid has any free resources that can get you connected with some counseling. All of those things. The same applies if it's a child protection matter. Don't wait until the proceedings are about to start or have started to start making those connections. Because in fact, these can even be part of your plan to say, I saw that things were going in this direction. I recognize that this wasn't a healthy situation for myself or my children, or even for my former spouse or my now separated spouse. So I started connecting with these community resources, and this was the result, or this continues to be the case, or this is the ongoing thing that we're doing. This one is a big one. Be teachable, be reachable. Review whatever application the CIS serves you with and start working to address the concerns right away. Remember, the CIS is not your enemy. It's their mandate to protect children. So they're just doing their job. So find out who your worker is and work cooperatively with the worker. Ask for and make use of whatever resources are available. And often, many times, these resources are available through the society themselves. Use their own resources to help you. Just make sure that they're culturally appropriate or culturally centered services, but get the help from them. Make it a team effort. Ensure that the society knows what your plan is and that they are invested in your plan working as well. These days, the society's outlook has changed a lot from what it used to be before. They're wanting to keep children with families. Ask them to help you keep your child with you or return your child with you. Ask them what it is that they need you to do and then do it. work with them. Okay? Make it a team effort. Call upon anyone and everyone who can help you make your plan a success. Sometimes it means from the other party's side of family. You may not get along with the other party, but maybe there's a grandma or a stepmom or a niece or nephew or uncle who can help. Maybe it's in your faith group, your church, your temple, your mosque, your imam, your priest, your somebody who can help. Draw on those resources. Amazing cases are lost because people don't do what they're supposed to do, and then they lose focus. That person who you are separating from, who is your child's father, may have been a terrible spouse, or your child's mother may be a terrible spouse, but it is that child's parent still. Terrible where they may be for spousal reasons, they are still parents and still have a right to see their children or interact with their children. So don't be unreasonable. Don't start with a premise of, oh, every visit should be at the supervised access center. There may be no need for that. That may be just your response to the situation and your anger talking. But again, it's not about you. Focus on the child. Ensure that the child has a time with the parent, and ensure that the parenting time is as reasonable and as easy and as flexible as possible, because it's for the sake of the child. Think about what the child enjoys. If the child enjoys McDonald's, or if the child enjoys movie night, parenting time could be there. Work it out so that it's easiest for the child and it's not about you. Even you, sometimes you need a break. You need your weekends. Ensure that could be tied into your plan, so that the weekend, when the spouse is having the child, is a time that you have for self-care and rest. Don't lose focus. Focus on the child. Don't view the worker as your enemy. We talked about that before. Whatever their concerns are, they're representing the state, and the state's mandate is to protect. So ensure that you provide that cooperation that's needed to move the matter forward and hopefully gets the child back in your care sooner rather than later. Don't engage in self-sabotaging behavior. This is an important one because often parties do that without even realizing it. If you start by just making the matter a war of words or a war of pleadings, court documents, then you get boggled down in something that is not useful for you or for your family. Your case could drag on longer because you're not focused on whatever the problem is. Avoid that mistake. Don't engage in that behavior. Don't be slinging mud at the court. The court doesn't want to see all that. Focus on whatever problem it is so that you can always come out seeming to be the person who is reasonable, who is understanding, who has thought about the best interest of your child, or the best way out of this situation, or the best resolution. And in all cases, inaction is your worst enemy. Not doing anything is the worst thing that you could do. And I think I will turn this over to Andrea because my part of the presentation is done, and she wants to share with you some resources. Thank you for your attention today.
Thank you so much, Vanessa. Thank you for that very, very informative presentation. I really, really appreciate you taking time out of your busy schedule to share your expertise with us. We really appreciate the important tips that you shared on telling one story. It's so vital that we do that when there's a family law matter. Particularly what struck me was your emphasis on interviewing a lawyer, and for, of course, emphasizing how important it is to tell the court what remedy you are seeking from the court. So thank you. We really appreciate you sharing those tips. Thank you so much again to everyone. We'll pop the survey in the chat. If you could please complete that, that would be really helpful. It helps us to plan further programs, have presenters like Vanessa with all her expertise to be able to provide us with presentations like this. Thank you again, Vanessa. I really, really enjoyed this presentation this afternoon. Thank you, everyone, for joining us today. And we will have some more webinars coming up. A copy of this webinar, along with the slides, will be posted on our website at onefamilylaw.ca. So thank you once again for joining us, and Have a good rest of the day. Thank you, everyone.